Hello, my name is Andrew Graham, and today I'll be giving a presentation on Internet regulation for Dr. Frederick Green's Business 501 class, Individual Professional Presentation. The topic of Internet regulation has gone from a relatively obscure legal niche to a major headline in news and social media with the explosion of broadband Internet access enabling the modern connected world we have today. No longer is the Internet just for simply transmitting limited academic research data or email, but is the foundation for much of our entertainment, social lives, and consumer businesses that we enjoy today. The regulatory and ethical framework approach that is taken towards the Internet will have far-reaching impacts to all of our lives. The topics that I will cover today will start with some brief definitions and history to provide a level set on the development of the Internet. Next, I will discuss major laws and regulatory bodies that have impacted the development of Internet regulation. Finally, we will take a look at the more recent controversies around net neutrality and where things are going in the present day. First off, let's take just a moment to define what we mean when we reference the Internet. The Internet is officially defined as a vast computer network linking together smaller computer networks worldwide. The Internet includes commercial, educational, governmental, and other networks, all of which use the same communications protocols. Simply put, the Internet is a network of networks. This is where it realizes its power. It is based on common communication protocols that are freely available and commonly understood. These concepts were started in government and academia and have been iterated on ever since. It is challenging to describe all the players and organizations involved, so we'll give a high-level overview here. It is interesting to note that the combination of government, academia, and private industry with open protocols and rules that have shaped the development of the Internet as we know it today. The Internet owes its roots to concepts started at MIT and DARPA in the late 1960s. Packet switching theory allowed for the communication of information to be routed from a host computer to a destination. The development of the TCP/IP protocol allowed for the mass expansion and routing of complex scenarios on the expanding network and for traffic to split off the military network. Federal agencies did assist in the development of common infrastructure like transoceanic circuits. Eventually, the backbone of the Internet gave way to commercially produced hardware. Some of the organizations and concepts crucial to the development of the Internet include W3C, an organization that was founded by Tim Berners-Lee. It is a worldwide consortium of partners working together on development of standards for the Internet. The National Telecommunications and Information Administration, which is an agency of the Department of Commerce that held the contract with the Internet Assigned Numbers Authority and the Internet Corporation for Assigned Names and Numbers. And two concepts that are crucial to its development: the Domain Name System, which translates human-readable domain names into IP addresses, and Internet Protocol, which guides routing through the Internet based on delivering packets of information from source to destination by address. Two concepts without which the Internet could not function. Finally, ISPs, which stand for Internet Service Providers. These are organizations that provide services to access the Internet's functionality. They can be organized in several different ways and are very much in the news regarding legislation and net neutrality. The Communications Act of 1934 was passed well before the thought of something like the Internet. However, we will see that it still has impacts today. Passed during the Great Depression and during a time of expanding development of wire and radio communication, it established that communications technology was an interstate good and therefore under the purview of Congress to regulate. The law established the Federal Communications Commission to enact that regulation. The law has many titles that separate the areas it covers, but one of the most relevant today is Title II. Title II established common carrier regulations, requiring telecommunications companies to make their services available to the general public at reasonable rates. Common carriers cannot make any unjust or unreasonable discrimination in charges, practices, classifications, regulations, facilities, or service. Now, this evolved out of other common carrier requirements as intended to prevent businesses, especially those in monopolistic positions, from excluding from the services as long as they are willing to pay a reasonable price. This was enacted during the time of AT&T. Until 2015, ISPs had avoided being classified as telecommunication services and instead were classified as information services, exempting them from Title II coverage. One of the first major laws concerning the use of interconnected computers was the Computer Fraud and Abuse Act of 1984. Despite the Internet's noble beginnings, it naturally follows that people would try to exploit or steal information for commercial purposes. This act formally criminalized accessing a computer without authorization or by exceeding what type of access the user was authorized for. This act targets government computers, financial institutions, or computers involved in interstate commerce, which in this day practically includes everyone due to internet connection. It contains sections regarding espionage, trespassing, fraud, damaging computers through viruses, trafficking in passwords, and threatening and conspiracy. The law is a criminal law and a statute that allows for civil cases to be brought for damages. Some critics of the law say that it allows terms of service violations to be considered a federal crime and allows terms of service to block ordinary activities or open up people to severe penalties for routine actions. The Telecommunication Act of 1996 was the first form of telecommunications since the 1934 Communications Act. Its objective was to provide a pro-competitive, deregulatory national policy framework designed to accelerate private sector deployment of advanced telecommunications and information technologies and services to all Americans by opening all telecommunication markets to competition. Critically, for the ISPs, it separated telecommunication services and information services. This eventually confirmed that ISPs would not be regulated under Title II of the Communications Act and were not considered common carriers. Telecommunication carriers would continue under the regulatory framework of Title II. This law laid the groundwork for the rapid expansion of broadband internet services by cable and traditional telephone companies. The goal was to allow anyone to enter any communications business. Continuing the laws, the Electronic Communication Privacy Act was passed in 1986. This expanded government restrictions on wiretaps from telephone calls to include transmission of data by computers. This was important as with the development of connected computers, new standards had to be implemented to protect the integrity of data on these networks and extend existing wiretap legislation into these new forms of data transmission. Title I of the Act contains more strict provisions that prevent data while in transit, developing requirements for search warrants that are more restrictive in their settings. However, Title II, which is the Stored Communications Act, protects communications that are being held in storage. This title contains weaker protections than Title I and lesser standards for warrants. This has come under criticism as the way data is stored has changed greatly since the law's implementation. With long-term storage of things like email common practice now, the standard for gaining access is simply a written statement saying that the information is relevant. This is part of a common debate on how we balance national security and criminal enforcement with civil protections. The Digital Millennium Copyright Act grew out of the World Intellectual Property Organization copyright, performance, and phonograph treaties. It increased actions against methods to circumvent technological protections against access and copying, for example, the DRM on purchased music or encryption on Blu-ray disc. Title II protects ISPs from suits that allege they contribute to copyright infringement if they prove that they are not actively encouraging it. Content holders were given the power to police ISPs and formally demand that they take down content that is unauthorized or disputed. A common occurrence of this is copyrighted material is posted to sites like YouTube, and copyright holders have the material taken down. Title II has been a major relief for content sites and hosts as massive amounts of copyrighted material are uploaded daily. We mentioned these organizations briefly in the history section, and now we will review some changes that have occurred recently. As we mentioned, the U.S. National Telecommunications and Information Administration is part of the U.S. Department of Commerce and acted on behalf of the U.S. government to manage a contract with ICANN for IANA functions. In March 2014, They call for complete privatization of IANA functions with several core values. These include a multi-stakeholder model to maintain security, stability, and resiliency of the Internet DNS to meet global needs and maintain an open Internet. For a little background on the companies mentioned, ICANN was founded in 1998 to assist the government with maintaining Internet infrastructure. This includes the DNS system, IP address management, and top-level domain creation, such as .com and .org. ICANN is responsible for the IANA transition. Net neutrality has become somewhat of a cultural phenomenon over the past 3 years for a somewhat technical topic. Celebrities such as John Oliver have gone viral with videos denouncing the FCC for planned changes to net neutrality. Perhaps most importantly, the President of the United States, Barack Obama, weighed in with a YouTube video in 2014 encouraging the FCC to protect net neutrality. So what is net neutrality that it would gain so much attention? This is the principle that when you access the internet, you should be able to access any content or application without restrictions or limitations by your ISP. There is a valid concern that ISPs could use their status to put commercial motives on internet access, limiting access to companies or brands they compete against, or throttling bandwidth by separating access into fast and slow lanes based on fees, and threatening smaller companies and artists. Advocates lobbied the FCC for classification of ISPs under Title II of the Communication Act of 1934 and won with a 2015 decision classifying ISPs as common carriers that are subject to regulation. This reclassified the Internet as a telecommunications service rather than an information service, reversing previous arguments following the 1996 Communication Act that affirmed ISPs as information services in 2002. The FCC has broad ability to regulate common carriers under Title II, and this drastically changes their approach to these providers. Under Title II, carriers must take all comers, provide just and reasonable rates, and there are increased disclosure obligations to regulators. On the other hand, critics argue that the competitive market is reduced under net neutrality, and this could lead to entrenchment of current powers, increased monopolies, and the stifling of the light touch regulatory approach to the internet since its inception. There is a fear that there will be decreased investment in broadband capabilities due to uncertainty of recouping investment if pricing flexibility is decreased under common carrier standards. Also, there are concerns about being able to uphold terms of service without being able to create dedicated lanes. The internet is a fast-moving market, and attempts at regulation are often outpaced by technological changes. Many other industries are able to differentiate on service and price to the benefit of consumers as long as entrenched monopoly power does not exist. The FCC outlined a new proposal to revisit the 2015 in May of this year. Its main points were to reinstate the information service classification of broadband internet service, remove determination that mobile broadband is not a commercial mobile service, restore Federal Trade Commission oversight of privacy practices of ISPs, and examine Title II regulations and the General Internet Conduct Standard, which critics see as vague and unenforceable. The context of this presentation thus far has been US-centric, but as the stewardship bodies for internet technology and standards move to a more global, multi-stakeholder approach, I'd like to touch on an example from around the world. China's approach to the internet as a major world economic player is in sharp contrast to the US. They gained internet access in 1994. Early use was encouraged, but once usage gained traction, the state in 1997 established comprehensive regulation regarding its use, including banning any activities that were found to harm the state. China considers internet usage inside the state part of their sovereignty to be governed by the state. The famous Great Firewall that filters content inside China was built as part of the Golden Shield project to enforce these stances. Many common U.S. news, social media, and search sites such as Google, Facebook, Twitter, The Wall Street Journal, and New York Times are blocked within the country. Most recently, VPN usage was made illegal. There is an uneasy balance as China considers its role in being a world partner while walling itself off from major areas of the dominant communication platform worldwide. Looking ahead, internet regulation and development are in the midst of a global change. Standards and practices that were previously US-centric are now transitioning to a global, multi-stakeholder approach. This is a good development as the Internet truly is a global network, and other nations should have a seat at the table. However, many nations have approaches that differ from the United States. We must look to safeguard the freedoms that we have in the Internet today as part of this transition. Net neutrality as a topic is likely here to stay as the FCC considers its previous rulings. Without new legislation, the administration currently in power may drive policy going forward. The role the Internet plays in our personal and professional lives has elevated it to something much more different than when the current legislation was drafted. Regulators must ensure that our social platforms and e-commerce transactions remain viable while increasing access and encouraging investments in our infrastructure. Internet privacy and how businesses and security agencies use and access our data will continue to be major topics. News stories regarding state secrets like the WikiLeaks controversies, social media controversies, and the right to have personal information removed from the Internet, data breaches, and worms will continue to dominate the headlines. The legal and regulatory framework will have to be updated to deal with modern privacy concerns and the ability to police wrongdoing using the infrastructure of the Internet. The Internet is not controlled by one person, government, or idea, and that has contributed greatly to its growth and power. It has given millions a voice and power that is often beyond the reach of governments, lobbying groups, and censors. Keeping this phenomenon growing while protecting those that depend on it for their businesses and personal lives will be one of the great challenges of the 21st century. Thank you for your time, and I hope that you enjoyed the presentation.